Hello and welcome to this episode of Parley, the Hindu's weekly podcast where we delve into pressing issues of public importance with insights from experts. I'm Aaratrika Bhaumik, your host for today. This week, we examine a critical question. Are the existing mechanisms effective in combating judicial corruption? This debate has gained renewed importance following recent allegations involving former Delhi High Court Judge Justice Yashwant Varma. Last month, unaccounted cash was reportedly found at his official residence. In response, Chief Justice of India Sanjiv Khanna has initiated an in house inquiry into the incident. Justice Varma has also been repatriated to his parent High Court, which is the Allahabad High Court, and will not be assigned any judicial work until the Supreme Court mandated inquiry concludes. To discuss the implications of this incident and also the institutional reforms required, we are joined by Mr. Sanjay Hegde, senior advocate based in Delhi, and Mr. Alok Prasanna Kumar, co founder of the Vidhi Centre for Legal Policy. Thank you so much for joining us today.
My pleasure, Aaratrika.
Thank you for having me.
My pleasure. Mr. Hegde, if I could begin the discussion with you, how effective do you think the impeachment process is as a mechanism to ensure judicial accountability, especially since it requires a high degree of political consensus?
Well, impeachment is not a measure of judicial accountability. It is actually a measure of protection of judges and to ensure their judicial independence. You've basically told Indian judges that look, short of Parliament actually voting by majority, two-thirds present and voting to remove you from office, nothing can happen to you. This was if you think that judges will be deterred by the possibility of impeachment and thus it becomes a mechanism of judicial accountability, I think we are all mistaken.
Right. And Mr. Kumar, do you agree with Mr. Hegde on this? And also, if you could elaborate on the grounds that are required for impeachment, which is proved misbehavior, incapacity. Now, this is also a very high threshold to meet, like Mr. Hegde also mentioned. So, what are your views on this?
We tend to take the idea of an independent judiciary for granted as if it was always with us. But it is a radically new idea if you think about it. Because judges were there to deliver the king's justice or the monarch's justice, however you want to design it. They were not there to place a check or protect the legal rights of individuals against the ruling regime in any way. It is only, I suppose, when the American Revolution took place and you had the Chief Justice John Marshall of the United States Supreme Court asserting that no, we draw our powers from the Constitution, so therefore we don't need to take your orders. The modern ideas of independence of judiciary really start to emerge and really start to grow. In behavior, judges can be independent. That's not what I'm saying, right? This is something sometimes it is confused in our conversations about judiciary. We think that if a judge acts independently, it means that judiciary is independent. Not necessarily so. Vice versa is also not true. You can have the institution of the judiciary completely protected from all sorts of outside interference, but the judges may still not act independently. So let's not confuse the two elements. As Sanjay rightly said, impeachment is supposed to ensure that the institution of the judiciary is independent, does not worry that there will be retaliation for verdicts which displease the ruling regime, which is why you have two high thresholds. One, you have essentially all of parliament requiring to vote, which is the entirely long and detailed procedure which results in impeachment. And two, it has to be serious misconduct. So in some senses, both substantively what amounts is sufficient to be removed for impeachment, and the process of impeachment itself is supposed to deter the executive from resorting to this procedure to get rid of judges that they find inconvenient. So let's not, as Sanjay rightly pointed out, confuse accountability with impeachment. It is a measure to remove judges, but that doesn't necessarily mean that judges are accountable to parliament in any way, or for that matter, to the people through the parliament.
Right. Thank you, Mr. Kumar. Mr. Hegde, what changes do you think are required in the impeachment process to ensure that, it is not just a mechanism to protect judges and there is accountability?
See, the point is that we chose to protect our judges, saying that parliamentary impeachment is the only way of removing them. But short of that, judges themselves have devised other mechanisms. So you can look at what they've done with Justice Yashwant Varma. They've said that he will not sit as a judge. No judicial functions will be assigned to him. The remedy of transfers was also resorted to earlier. In fact, what they've done with Justice Verma was done by Chief Justice Sabyasachi Mukherjee to when Justice V. Ramaswamy was being impeached by Parliament. Justice Mukherjee ensured that he would not sit doing any judicial functions. And in fact, even after surviving the impeachment motion, Justice Ramaswamy then did not return to the bench, if memory serves me right. He just retired without hearing any further cases. I don't think there is any process where if impeachment is the only exit route, you can refine. You can't have something short of an impeachment or anything like that in Parliament's hands. Within the judiciary, now they have devised at least keep the person out of power kind of situation, or they've decided that we will utilize the person in some other capacity as a judge in some other high court. There may be uh, more public scrutiny and uh, transparency if things like declaration of assets and how specific complaints when made to high judicial quarters are dealt with in a transparent fashion. Often, what happens is that a lot of complaints come in, and many of them are just disappointed litigants. They may not have a basis for what they are saying, but if there is any serious complaint, the judiciary must have a mechanism where they're transparently dealt with. That would go a long way in preserving public faith in the judiciary.
Right. Mr. Hegde, you of course mentioned the in-house procedure that has been resorted to when it comes to Justice Yashwant Varma. Do you think there are legislative reforms required when it comes to the conduct of this in-house inquiry procedure? For instance, setting of timelines for the inquiry committee or more transparency in general? No, Mr. Hegde, this is a question for you.
Those are legislative calls. The legislature has already currently decided that it what the procedure for an impeachment will be, and there the Judges Inquiry Act has come in. Now, this in-house procedure is something that the judges themselves have devised, and this has happened more so in the backdrop of what happened with the district judge in Nadia in the late 80s and 90s, where a policeman who had a fight with him just arrested him in a prohibition matter and produced him in handcuffs before another judge. They Thereafter there were corruption cases involving Justice Veeraswamy, father-in-law of Justice Ramaswamy, and there in the Sarojini Ramaswamy cases, it was decided that yes, it is not as if judges are immune from the normal process of law, but we should also be aware that sometimes normal processes of law can be misused against the judiciary, particularly when the administration of the day doesn't like some of their judicial calls. So, therefore, If the administration of the day feels that there is a criminal case made out against a judge, bring it to us. We will have an in-house inquiry first, and then we will tell you go ahead with the criminal case, or uh, suggest that there is nothing in it. So the filter that the judiciary has put on in such a manner, maybe Parliament needs to take a look at it.
Right. Thank you. Mr. Kumar, what are your thoughts on this? How far do you think the in-house procedure has been effective when it comes to corruption cases?
Corruption cases are a particularly challenging kind of case, and I think this is something we shouldn't forget, that it's not as if this country is regularly prosecuting people for corruption cases in all other situations, and it's just the judiciary where you're having a challenge in doing so. Let's not forget that the 2G case ended in acquittal. Let's not forget that the coal scam cases are slowly but steadily falling apart. Let's not forget that the iron ore scam accused are still facing trial. And this is, and I'm talking about a high level. I'm not talking about some low level officer who took 100 rupees from this person or that person. I'm talking about very high level corruption cases are not easy to prosecute, and that's irrespective of the a body of government where such corruption is said to have taken place. With the judiciary, and I can point to the most recent example we have seen in the context of Justice Nirmal, where a full-fledged trial has taken place. This is after the in-house procedure has been followed. The Chief Justice gave sanction and approval for her prosecution, and they said there is enough material to prosecute her. She was prosecuted, and what happened? An acquittal. Honestly, that is a terrible judgment, and I hope that it is overturned in appeal. But it's not easy to prosecute someone for prosecution for corruption, especially in our country where the institutions of prosecution are weak, where capacity to punish for prosecution is weak, and on top of that, you have a sort of institutional protection for judges, which, as Sanjay pointed out, is rightly so because every losing litigant thinks they've lost the case because the judge has taken money. Uh, Again, having said that, I still think there is scope for the in-house procedure to become more robust, because, and I was reading today, when we're recording this on the 9th of April, that the three judges who were looking into Justice Varma's case, they have resumed charge of their courts after 15 days of taking evidence and so on and so forth. Now, if on a day-to-day regular basis, the proceedings of a court are open to the public, again, as a measure of accountability, we don't think measure accountability is just a stick you beat someone with when they don't follow the rules, as to how the institution itself functions also, which ensures some level of accountability. Can we not know what was said in these proceedings? Can we not find out what was said in these proceedings? What was the merit that that the three judges found in the statements that have been made to by various people to these three judges in these proceedings? At the end of the day, you can't treat the judiciary as a regular government office. This is what I want people to understand. You can't say, I will give you discretion to decide cases in accordance with the law, and what you say is the law, but I want you to exercise the discretion in such a narrow, constrained, absolutely explainable way, as if you are a collector deciding who will get what allotment under what scheme, right? These two things somewhere need to be balanced, and we can't, while we can say a collector has violated the rules for having said so, with judiciary, unless you have that mechanism in place to understand, to like to be able to say that these are their assets, it's really hard to ensure accountability. It's really hard to crack down on corruption. Procedure might improve the public's confidence in the procedure. That's all that it can do, but it cannot per se be a deterrent to corruption in the judiciary.
Right, Mr. Kumar, you mentioned about transparency when it comes to in-house procedure. So we've seen in the Justice Yashwant Varma case where the internal inquiry report was made public by the Chief Justice. So do you think this kind of transparency is welcome, or does it lead to more speculation?
No, it's welcome. And I think we have to understand we are living in a very different world in 2025. In 2025, the Supreme Court and the High Courts, and to a lesser extent the district courts, are covered in the mass media and in social media in ways that were unimaginable 15, 20 years ago. Sanjay has been in practice much longer than I have been, and I'm sure he has seen the Supreme Court in a much closer way. But I don't think there was a time when the Supreme Court or even the High Courts were covered in such detail by the mass media on such a regular basis, that to the point that the names of chief justices aren't some obscure trivia that you remember, but they're on everyone's lips when discussion takes place. uh, on keep to keep the question, there needs to be therefore much more transparency in how the court responds. Not just talking about this particular instance, I welcome this. I welcome the fact that they've put out this information in public, the fact that they've tried to make everything transparent, the fact that they're going to try and make as many more things transparent. But this can't just be a reaction. Transparency isn't just a way to cover yourself after a crisis has erupted. Transparency is what prevents the crisis from erupting in a particular way. And this is where I feel, we went back, and to around 2015 or so was when judges of the Supreme Court stopped making their asset declarations public. They were making asset declarations apparent to the Chief Justice, but they stopped making these asset declarations public. And the judiciary is an institution where a lot of norms flow top down. And when you stop making that public, you kind of said, no, there are some things we don't trust you, the public, to find out or know about. And that, I think, is something which has to be remedied. Now, I saw through news reports that Chief Justice Khanna has said that Supreme Court judges have agreed to put all their assets in the public domain, which is great, which is welcome. But this should be the norm. It shouldn't be a knee-jerk reaction, or it shouldn't be like a attempt to rebuild public faith in a moment of crisis. It's good that you have done it, but you have to institutionalize it. This transparency should be institutionalized. What is the next? I mean, it to me, it baffles me, and this what baffles everyone, that a judiciary which has been so adamant about public representatives such as MLAs and MPs making all their information public while standing election, takes the direct diametrically opposite approach when it comes to their own assets and their own relationships and their own dependents. So I think the judiciary should be far more transparent. This is a welcome first step, but it should not just be a reaction to a crisis. It should be the way in which they think about their work to the entirely, and their duty to the public entirely.
Right, thank you. Mr. Hegde, do you agree with Mr. Kumar on this?
Yes, of course, I do agree with what he said. But the Supreme Court has not made the inquiry report public. What it has made public is all the material that was submitted to it earlier. So the inquiry is right now going on, and that will come out with a report, which I can reasonably anticipate will be made public unless there is something which requires to be protected in the interests of the defense or something of that kind. That I can't. I would think that they would make as much of the internal inquiry public as possible. But I think the court's hand was forced in a certain way, also because there were questions all around as to what exactly were the allegations, and there were all kinds of theories about the allegations. So till that video came out, people did not really appreciate the magnitude of the allegations. And I think the Supreme Court did a good call by putting the video out itself, because if the video had been leaked from some other source, then it would have looked as if the institution was covering up for a member of the higher judiciary. So yes, it is welcome, but I don't see what other option they had.
Right. Mr. Hegde, what I essentially want to ask you is that do you think transparency, at least when it comes to publication of the final inquiry report, should be a norm? We have seen more transparency regarding Justice Yashwant Varma's case. We have not seen this kind of transparency, for instance, when it comes to the in-house procedure initiated against Justice Shekhar Kumar Yadav of the Allahabad High Court. So there is criticism that there is selective application of such transparency norms.
I don't think that the court was trying to be selective. And as far as transparency is concerned, uh, there will be other considerations also, because if the Supreme Court releases something and then thereafter there is an investigation, and after the investigation a trial, the Supreme Court cannot prejudice anyone. and especially somebody's right to a free and fair trial. So this would really have to be on a case to case basis. As far as uh, what Justice Yadav said or did not say, I do think that certain minutes at least or an agreed statement should have been put out. The court cannot just sit back and say, please trust us, we are doing what we can. Everything should be documented, everything should be communicated, and the communication should be in clear language. Even in the Justice Yashwant Varma case, at an early stage itself, it was said that Justice Varma had to transfer, while there hadn't been any such order, recommendation by the collegium, nor had there been an order by the government. So uh, they came out with a press release which was full of legalese and gobbledygook, which had to be decoded by lawyers. It is time that I think that the Supreme Court and the courts have dedicated communications personnel who could advise them, maybe even on a contractual basis, as to how clear non legal communications for the people at large are to be put out.
Right. Thank you, Mr. Hegre. Mr. Kumar, I would like you to address one aspect. So, the in-house procedure that currently exists, it is silent on the procedural and evidentiary rights of the accused judge. It only states, for instance, that the committee is free to devise its own procedure, which obviously has to be consistent with the principles of natural justice. But no cross-examination of witnesses is allowed. So, do you think more has to be done or reforms are required to secure the rights of the accused judge in such cases?
It, procedure is always a function of the seriousness of the consequence. If you see the procedure which is followed for, let's say, a disciplinary inquiry, it is not the same as a procedure for a criminal trial, let alone a criminal trial for a serious offense. And yes, at the heart of it is principles of natural justice, but it's always a balance that needs to be struck as to what is likely to ensure that the outcome enjoys the confidence of everyone involved. There is a risk with sort of say cross examination because the investigation is not complete. Let's not forget that there is potentially an active criminal investigation. You have not found all the facts. It's not as if everybody is coming into this having being in full knowledge of all the facts possible. The mandate of the committee is essentially to say, is there something which requires investigation or further action? So I think to that extent, yes, you may not need very detailed, which could prejudice eventually the actual finding of fact which takes place. So, which is why I think there needs to be something in place, but perhaps not as detailed as in a criminal trial, which might end up making findings of facts that are so complete that either there is nothing left to try or you prematurely effectively give someone a clean chit. So, which is why I think the procedure can be improved, can be made a little bit more clear. But here's the challenge, right? It's not as if, see, regularly in a civil court, judges handling a trial every single day. They're following a procedure which they need to follow for every single case. These are not cases which come up every single day, right? This committee is sort of looking at a kind of case which comes up once in a blue moon, right? Hopefully. Uh, so it's not as if there has to be one hard and fast set of procedures that they have to follow. You have to ensure that yes, everyone is given an opportunity. You can sort of make it clear, but I don't think you can make such hard and fast procedural rules that the proceedings of this committee itself become the basis for further litigation rather than actual fact finding and actual prosecution. So I think some balance needs to be drawn. Maybe there is scope for improvement, but I don't think we should have an expectation that it should be like the Code of Criminal Procedure or the BNSS, where every single thing is laid down in as detailed a manner as possible.
Right. Thank you, Mr. Kumar. Mr. Hegre, if you could now talk a little about the appointment process of judges, which is, of course, very contentious. The entire Justice Varma incident has been co opted to advance the political argument for establishing the NJAC. Do you think that the government should have a seat at the table when it comes to judicial appointments?
The government has a seat. It already has a seat. The question is whether it should have a blank check. See, today it is not as if the judiciary can appoint whosoever it wants. Obviously, there are soundings taken even before names are forwarded. After they are forwarded, the government still retains the power of bringing to the collegium's notice what the intelligence agencies have found out about the man. There have been instances where the intelligence agencies have been so intelligent that they described a particular gentleman who was being considered. They described him as a drunkard. The truth of the matter was that because he was a teetotaler, his friends at the bar called him Boozer. As a consequence, his appointment could not be cleared with with a particular lot of judges, and then he had to be appointed much later. And that happened only because the chief justice of the day happened to know the correct facts. So, at every stage of the appointment process, the government has a seat at the table. It is not the only place that they don't have a seat is right in the beginning of the collegium recommendations. There, technically, these are recommendations which are made simply by the judges themselves. They have a further seat in as much as even after the collegium has recommended and there is nothing adverse found against them, there have been instances where they've simply refused to make the appointment. While the case of Mr. Saurav Kirpal is well known, there have been other cases like Aditya Sondi or John Satyan. Anybody whom the government is determined not to appoint does not get appointed. The government has taken upon itself a veto through the memorandum of procedure, and it is exercising it fully. It is because the government has a seat at the table that we have not had judges like Justice Akhil Qureshi and Justice Murlidhar make it to the Supreme Court.
Right, absolutely. Mr. Kumar, of course, like Mr. Hegde mentioned, there is considerable executive veto that we see in judicial appointments. But do you think that a change is required when it comes to the functioning of the collegium system as we see today?
I've said this in other places and I'll say it once again. I don't think we should even be calling this the collegium system anymore. For all the reasons that Sanjay mentioned and many more, I think this is really the search and selection committee system. The High Court, quote unquote, collegium and the Supreme Court, quote unquote, collegium recommend names. The union government adopts a pick and choose policy. They appoint some people, they don't appoint some people. Some people they appoint as they please, and some people they keep hanging with the deliberate intention that the people withdraw their names. And this has happened quite often. The result of this is also that preemptively, and you will hear this again and again from judges, preemptively, a lot of meritorious candidates who have no political inclination one way or the other are saying, thank you, I don't want to subject myself to this humiliating procedure where my reputation is damaged because of the fact that somebody somewhere may, as Sanjay pointed out, come up with some random nonsense and put a pause to my appointment. So we are in the worst of all possible worlds when it comes to judicial appointment, if you honestly ask me. Frankly, if the government were to tomorrow pass an NJAC Act in exactly the same terms as they proposed to do so back in 2015, it would be a welcome improvement over the situation that we have today. But quite honestly, the real problem with the system is not who is making the appointment, it is the how. I will repeat this. It literally doesn't matter if it is just the government picking the names or if it is the judiciary or some combination of the two. What matters is, does the public know why Mr. X or Miss Y is being made a judge, or why Mr. B or Miss A is not being made a judge? I think that is the more important thing, because today, if the US Supreme Court and the US judiciary, despite the fact that literally people call them Republican judges and Democrat judges and Trump judges and Obama judges, there is still faith and there's still confidence that they can act in a certainly independent manner, and that they don't always decide in cases as the way people expect them to. It is because they are, at the end of the day, competent and efficient and honest lawyers who've become judges. By and large, of course, there are exceptions everywhere. Of course, bad apples get into the system. But if you don't have a system which can tell a bad apple from a good apple apart, you are going to shatter the public's faith in the system. And that to me is the bigger problem, that we don't have a procedure which can tell people this is who we are appointing. I think the Justice Chandrachud Collegium at least made a good dent in this by having detailed minutes of the collegium identifying why we are choosing this person, why we are choosing that person, what is the qualification, or even their unwritten criteria why they want to this person to become a judge. Unfortunately, that healthy practice was stopped in the Justice Khanna led collegium, and except most recently in the context of now Justice Bagchi. So I think what is really needed is criteria, transparency, and efficiency in the process, not really who picks and who doesn't pick. To me, these are the serious problems. If that is fixed, it really won't matter who picks at the end of the day. Once people feel confident that only the best lawyers and only the best subordinate judiciary judges are being picked for the higher judiciary, it doesn't really matter if the government is doing it today or if the judiciary is doing it the next day. I think that is the main point to take away from this.
Right, Mr. Kumar, do you think? I mean, there has been a lot of talk of, let's say, even the Congress leadership has shown its support for the Judicial Standards and Accountability Bill, which was passed in the Lok Sabha in 2012, but of course, it was not enacted into law. Do you think an establishment of, let's say, a body like the National Judicial Oversight Committee could help? It could be a better alternative.
I'm not so sure, because I think we have a very school teacherish approach to accountability in this country, that we think only when someone is sitting over you with a big stick on their in their hands, that is what ensures accountability. I don't think so, and I think we need to be more nuanced about how we think about accountability in this way. Yes, standards are there, but can we crystallize those standards first? Can we first make it mandatory for every judge to list out every single relative of theirs who's practicing in the same high court, right? Because that may just be enough for most people to, say that, yeah, this is a problem, please transfer that person. Or, yeah, this person should no longer be practicing in this court. It's a known gossip in the high courts as to who's uncle judge, as they say popularly. But I think, can we crystallize these standards into actionable do's and don'ts for the judges, that don't sit on cases like this, declare your assets like that, don't have your relatives appear before you, etc., etc., etc. I think, more than having a body sitting on top of everyone else and building, because who's going to sit on this body? Who is going to keep staffing these bodies that we're endlessly creating one on top of each other? It's the same set of people. The Lokpal is what filled with other retired judges. Now that is another issue which has caused controversy in the court. Can the Lokpal now oversee the corruption cases against judges? It's pending. There is a problematic order of the Lokpal. Fair enough, the Supreme Court is considering it. But my point is, I think we should do away with this somewhat school teacherish idea that, it's only somebody wielding a big stick who will ensure accountability and transparency and fairness in the judiciary. And perhaps there are more readily actionable points for us to do, which may end up having the same effect.
Right. Thank you, Mr. Kumar. Mr. Hegde, what are your thoughts on the bill? And of course, like Mr. Kumar mentioned, the order of the Supreme Court staying the Lokpal order.
Yes, I agree with what Alok has said. We do tend to focus a lot on the school teacher approach, but I think we have not focused enough on the question of on how the legal profession is a process of constant peer review. It is not as if uh, judges who have gone bad suddenly go bad. Much before anything gets revealed, the mutterings are always there. The whispers in the corridors, the constant review as to why a particular judge or lawyer behaves in a particular manner in a particular courtroom. All these are not entirely unknown. It may, to my mind, be quite a improvement if there was some way of making this peer review uh, also part of the process of accountability. there was an innovative idea once in the state of Uttar Pradesh with regard to the bureaucracy. The bureaucrats themselves held a poll as to which among them was the most corrupt. And there was a ranking. And later on, many of those people who were voted very corrupt, they did find themselves at the receiving end of criminal investigations. I don't know how exactly this can be done, but maybe the bar associations or the judges themselves should have the option of voting out one of their own brethren in every year, voting for that person to be transferred away from their normal field of action,
But
and that should be made public.
right. But do you think that the bill as it stands today would not really be the solution that we're looking for? You would want a more peer review
It
mechanism to also be a part
it,
of.
it goes to some part of the way, but it can do with improvement. And since it's been quite some time,
Hmm.
maybe it needs to be updated.
Right, right. Thank you, Mr. Hegde. Mr. Kumar, since Mr. Hegde actually mentioned the entire getting comments from your peers and having that form of consultation case, that reminds me what I want to ask you is there a need to kind of liberalize the criminal contempt of court laws that we have today, which would, for instance, allow for greater public scrutiny of judicial conduct?
See, we can liberalize the laws as much as we want, but as long as there are no consequences on the judges who illiberally use them, I don't know what difference it will make. Sure, the text of the law can be that yes, you will not hold for criminal contempt unless they do A, B, C, or D. But when you have judges who are fundamentally insecure, who are fundamentally unfit to hold that position, who find themselves being called out in a public way, they will use these to retaliate. And the point is, where is the mechanism then to impose consequences on them if they retaliate, right? I think that has, of course, the norm aspect of it has to be addressed. You want a more liberal criminal contempt law, but I think it's also about procedure in terms of is it a judge responding in a fit of rage, anger, insecurity, or fear, or is it an institutional response to a person who's trying to steadily undermine the judiciary and its standing in the public through a steady series of misinformation and lies and so on and so forth? So I think that is where we need to draw the line, and I think that is where we need to kind of have a more nuanced conversation about this. That there is no one easy fix-all solution to it. There is no one easy. If we liberalize it, more people will talk about it. In a way, I think it's a radical idea that Sanjay has mentioned, but in some ways, can we not make this more public? Can we not sort of have the bar's inputs taken on board in a public way, right? Let the bar nominate who they feel is suitable, and then the judges can pick names. I mean, may not again be the best way, but if the public were to know that here is a person who is voted consistently by their peers as best advocate, we see them appear regularly in court. So it's not just one person. I'm sure it'll be about 50, 100 people, and when that such a person becomes a judge, there is confidence that yeah, okay, this person has a certain standing. If somebody has been in the public domain, who has taken a certain position, who's taken a certain thing, and there is a certain sense that this is a person who actually works for justice, who appears fairly for clients, who enjoys the respect and confidence of their peers when they're appointed as judge, that personality won't change 180 degrees. I mean, whatever it is, all of this is eventually also subject to the idea that whatever you try to measure will also sometimes bounce back against you. But I think, in some sense, more than criminal contempt, I do think that we need some way where we can have this conversation about corruption in the judiciary without sort of having the judiciary shut it down. Contempt is one way that they do it. Yeah, I'm sure we can definitely liberalize those laws, but there may be less obvious ways in doing it. Lawyers who can constantly raise these issues may find that they are shut out of senior advocate designation, that they don't get the relief for their other clients when they sometimes do so. They may say, what's the hassle? The system itself doesn't want to respond. Why should I become a martyr to the system, and why should my clients become martyrs to the system? So I think, this what this begs, and what this issue of Justice Yashwant Varma really begs of us, is, can we have a more honest conversation about corruption in the judiciary, rather than just resorting to simple everyone is corrupt, or oh, nobody's allowed to talk about corruption, or that no, there's only a few black sheep here and there. Maybe a more honest conversation is needed, and perhaps that cannot just be driven by one side being being afraid of the threat of criminal contempt.
Right. Mr. Hegre, what are your thoughts on the contempt of court laws that we have currently? We also have precedents. For instance, since we're talking about judicial corruption, we've had contempt of court proceedings initiated against journalist Madhu Trehan for her article on the Delhi High Court judiciary. So, do you think there are reforms required here?
Well, there certainly, and Alok is right that even if you reform, the a malevolent judge uh, can use it as a measure of lawfare. But while you cannot entirely do away with criminal contempt, uh, there there would have to be safeguards put in the system. And yes, you mentioned the Madhu Trehan incident, but Madhu Trehan, and to my mind, was not even being contemptuous. It was just a ranking of judges. It was just a ranking of judges, and so it did not bring into disrepute the institution. You can always say that so and so is a good cricketer, so and so is not a good cricketer. That doesn't, or is not as good a cricketer. Not every cricketer can be a Tendulkar, but unless you say that Tendulkar is number one, hi, that's not necessarily being disrespectful of Dravid or VVS Lakshman or any of those people. The judges need to be sure that they have uh, not too thin skins, but broad shoulders that can shrug away uh, even outspoken comments.
Right. Thank you, Mr. Hegde. So, before we conclude this episode, I would just like to get your concluding thoughts. Are you happy with the institutional response that we have seen so far? And in general, what reforms are required?
I wouldn't say I'm happy. I would say I'm satisfied so far. I would say that I think the transparency shown, the speed with which the court has responded, I think that is satisfactory. There is much more that needs to happen, and we're waiting for it to happen. So let's not prejudge anything. Uh, but I think the reforms really have to start at all ends. We're not just talking about accountability, as I said earlier, as a big stick to beat someone with. Let's start with the process of, can we have an appointment process that inspires public confidence that the people are appointing as judge are persons with integrity, competence, and efficiency? And can we lay down standards of conduct which give a clear set of do's and don'ts to judges while they're in office? And can we ensure that the procedure by which you assess whether a judge is done their duty or they have failed in their duty in some way is also going to inspire confidence in the public? I think these three very broadly is where I would put any scope for reforms in. The biggest elephant in the room, of course, being that you can't have this hypocrisy of, the government saying it's the judges who appoint judges when they really it's the government that is appointing the judges.
Right. Thank you. Mr. Hegre, any final thoughts?
And the final thought is, it did not, it should not have come to this, that a fire had to start somewhere where we thought of reform. Reform and upgradation should be a continual process. The bar and the bench are not adversaries. The way I see it, you cannot have corrupt judges without crooked lawyers. If As this inquiry goes on and more facts are revealed, uh, if action is to be taken against judges, and at the same point of time there are lawyers who are found involved, I do think that the bar council and others should exercise their own procedures. We do need to have a restatement of values, not only on the part of the judges but also on the part of the bar.
Right. Thank you, Mr. Hegde. Thank you, Mr. Kumar, for joining us today. This has been a very insightful conversation.
Thank you.
My pleasure. Thanks, Aaratrika.